Greetings to everyone. It's a great pleasure to welcome you to the third seminar of this academic year organized by the Climate Change and Law Laboratory of Kadir Has University Law Faculty. Today we have a very special guest, Dr. Ivano Alogna. Normally we would also host Prof.Dr. Duncan Fairgrieve, but unfortunately he will not be able to attend today since there is a sickness, but we wish a prompt recovery for him. And before we start, I would like to introduce Dr. Alogna to you. Dr. Ivano Alogna is the research leader in environmental and climate change law at British Institute of International and Comparative Law. He is an associated member of the Sorbonne Research Institute in International and European Law, Sorbonne Law School, a member of the European Law Institute project on ecocide, and is currently a Glasgow Law Fellow at the University of Glasgow School of Law. He lectures on various courses such as global environmental law, climate change law, environmental liability, private law, sustainable consumer law, and comparative law. He is the co-editor of the book Climate Change Litigation, Global Perspectives, and of a forthcoming volume on climate litigation in Europe. He holds a PhD in comparative and international environmental law from the Sorbonne Law School and LLM in environmental law from the Universities of Paris-Dauphine and Paris-Dauphine. He is currently leading at British Institute of International and Comparative Law a new project on global perspectives on corporate climate legal tactics, aiming at developing a global and practical toolbox in corporate climate litigation. Yes, Dr. Alogna, I would like to thank you for accepting our invitation. We are very honored to host you in our seminar series, and we are really excited to listen to climate change litigation in Europe from a comparative perspective, and therefore I leave the floor to you.
Thank you very much. Thank you very much for this introduction. Thank you very much for the invitation. It's really a pity not having with us our colleague Duncan Fairgrieve, but I'm sure that we will have other occasion to be together, to organize something together, and it's a pleasure to be with all of you. As I was introduced, in this moment, in the last 3 years at BICL, at the British Institute of International Comparative Law, we are working especially in the field of climate litigation, which is becoming something more than a global trend or another kind of field a la mode. Is becoming really something that, in a way, we really believe that can make the difference in this very difficult moment historically for all humankind. So if I have the possibility of sharing my screen, I will try to show you my slides. Let me see. Yeah, can you see them?
Yes, we can see.
Perfect. So in reality, I was going to talk about with Duncan about a paper of us that we are working on in this moment, which is on climate change litigation in Europe. Since Duncan is not here, I prefer to open up a little bit the perspective. So we will have a global perspective instead of the comparative law one. So you will understand what we mean by that, just that I'm adding also the international perspective to the comparative law one, and also enlarging a little bit more to the European Union and European level, because I think that this is really a field, climate change litigation, in which we have really the possibility of seeing this circulation of legal ideas, models, and also this dialogue between the judiciary. And so it's worthwhile to give an overview. At least I will try to give an overview because, as you know, this is a field that is quite young, but has been developed quite strongly and rapidly in the last years. So I will try to give you this global overview on climate change litigation. And I hope at the end, or you can stop me whenever you want. Just raise your hand or unmute yourself if there is something that you want to be clarified, or if not, we will wait until the end for a Q&A, for the Q&A. So let me see. Yeah. this is, as you can see in this outline, the idea is to show during this session a short introduction of the topic, followed by the presentation of what I consider a really invaluable tool for its analysis, the climate change litigation databases. These are really important when we start working on climate change litigation, because we realize that we have already a lot of materials that we can use, and it's really important to start from that because it's pretty practical. And then we will see different definition, types and elements of climate change litigation before analyzing its global perspectives. And then I will finish with some conclusions. So as an introduction, let me start from the object of this kind of litigation. When we're talking about climate change, as you know, we generally say it is an always more evident super weak problem. So time is running out. There is no central authority to tackle it. And those seeking to end the problem are also those that are causing it. So, as you know, there is an elaborate international climate regime, which, you know, is formed by the UNFCCC, the UN Framework Convention on Climate Change, the Kyoto Protocol, the Paris Agreement. But as you also know, the states are unfortunately lagging behind in comparison with the rapidity of climate change. So just last month, before COP27, there was the publication of the Emission Gap Report 2022, the closing window. Climate crisis calls for rapid transformation of societies. This is, and now it's become also almost a tradition since a few years. It's the UNEP that is publishing this. You can see this publication on the top right corner on your slide. And this finds that the international community is falling far short of the Paris goals, with no credible pathway to 1.5 degrees in place. So what this tells us, that only a very urgent systemic-wide transformation can avoid climate disasters. And this always more evident failure that I was mentioning by national but also international policymakers has required other actors to react in order to tackle climate change. And that's why, in a way, climate change litigation in the last years is taking the lead. It's taking the lead in tackling climate change, and we start seeing lawsuits in which not only NGOs or citizens, but also activists, shareholders, investors, cities, and states, they challenge local authorities and national governments' actions or inactions. So in this way, climate change litigation can be considered as an important component of the governance framework. This part also of which we were saying, the international regime, this is the governance framework that has emerged to regulate how states respond to climate change at all levels, because, you know, it's a multidimensional and multi-level kind of governance. So we talk at the global level, the regional level, but also the local level, which is quite important, especially when we talk about adaptation or with about some particular instrument that we need to tackle this crisis. And as you know, this is something that is done by exerting pressure on the executive and on the legislative branches of government to act on climate change issues. So at the same time, as you know, climate change related cases have been filed also, also against private actors. As it was said at the introduction, we are working at BICO on a new project on corporate climate litigation. The name is much more academic, that is the goal. This global perspective on corporate climate legal tactics is no other than the idea of creating a global and practical toolbox on corporate climate litigation. And so in this kind of cases that we are analyzing around the world, we see this new trend where the carbon majors, the major greenhouse gas emitters that, as you know, are mostly fossil fuel and cement companies, they are brought before judges. And so we start to see something that is really interesting, because, as you know, 80% of CO2 emissions are coming from these entities. So maybe it was also worthwhile starting to study a little bit more in detail. So this is a project that we started this year. You can see this kind of project on the website, on the BICO website, on the British Institute of International Comparative Law. Just to conclude this short introduction, we must add that this year, for the first time, the Intergovernmental Panel on Climate Change, the IPCC, that everybody knows, has recognized that climate change litigation can affect the outcome and ambition of climate governance, as you can see on your slide. So this is really something that has started to become really recognized even at the highest level of our scientific community. So, climate change litigation databases, as I promised you, since the beginning of, let's say, this wave of litigation involving climate-related issues, that was the early 2000-ish, the literature on climate litigation in law and social sciences has grown steadily. And so also the development of this body of scholarship that has, in a way, largely tracked the exponential growth in the number of climate-related cases. And so we can say that at the beginning of the 1990s, there was something like a handful of cases, especially in the US. Of today, there are more than 2,000 cases. I was checking a couple of weeks ago, was something like 2,100. And these are at least the cases that have been identified in the first of the database that you see on the slide, the climate change litigation databases developed by the Sabin Center for Climate Change Law at Columbia University, which is, we can say, the group of scholars and the biggest databases that we have in the world, because, of course, as I said, the US is quite important. This database is quite interesting. You will see, just put climatecasechart.com, and you will find 45 countries covered and 10 regional or international jurisdiction. We should say why we have the first database in the US, of course, because also maybe almost 3/4 of the total of climate litigation cases are identified in the US alone. So, you know, let's say that that was also the reason why this became a starting point with Michael Gerard and his pioneer idea of creating the Sabin Center at the beginning of the 2000s. So after the US, you can see here there is another common law country, which is Australia, that has the second largest number of climate cases globally. And that's why also we have another database that has been created by the Australian Climate Change Center, so the Center for Resources, Energy and Environmental Law at the University of Melbourne. And this database, this climate change litigation database, it has more than 200 cases that have been filed before Australian courts, plus some cases coming from New Zealand and Pacific Island countries. So complementary to the first one. Another very important global database is provided by the Grantham Research Institute on Climate Change and Environment. So the London School of Economics, just to be clear, in London. And this is a database that is even more heterogeneous because the name is, as you can see, Climate Change Laws of the World. So this is a database that covers both national level climate change laws and policies, but also all the climate change litigation cases. And that's why they created a partnership with Sabin Center to be sure they agreed also on the cases. And why I say that they should agree on the case, because in a way, as you see, it's also important in order to understand what cases could be part of this, let's say, of this field. It's important to understand also the definition that we give of climate change litigation. So about the definition, I try to sketch the definition that we find a little bit more interesting and we find more often in the literature. So in legal literature especially, there are two main approaches that dominate the debate on the definition of climate change litigation. As you can see, on one hand, we have what we call a narrow definition, according to which climate change litigation only covers litigation which directly and expressly raise an issue that is related to climate change or climate change policy, of course. An example is this definition that I copy and paste, provided by Markel and Rule two American scholars, quite interesting definition. On the other hand, we have a broader definition. I mean, there are broader definitions because there are many definitions of climate litigation, but because in a way, the idea is to, in addition to the explicit reference to climate change in the proceedings or in decisions, the idea is also to consider climate litigation according to the motivation of the plaintiffs, as well as the cases where climate change is not maybe the central topic, but rather an additional or secondary concern, even when climate change is not expressly mentioned. So in this regard, I provide you this definition by two other great scholars, Jacqueline Peel and Jolene Lin, so from Australia and from Singapore. And in their view, such a broader definition is especially required when we consider litigation in the global south, as you can see, where a significant number of cases reflect a peripheral focus on climate change rather than having the issue at the core of the litigation. So in a way, it allows us also to extend the boundary of this kind of litigation, including litigation that are not really according to the narrow definition, could be considered climate litigation in the North. So this is quite important, especially from a comparative perspective, the kind of definition that we give of this field. So there are also different types of climate change litigation. I think that just to have an idea, because there are many more than this, as you can see here from the picture, the last few years have seen an evolution of the, let's say, climate change protection panorama, climate change law also, and also, of course, as I said, the climate change litigation landscape, the advent of global climate protests, as you know, such as Extinction Rebellion or Fridays for Future, in a way was quite important, have been quite important because it's shown a spotlight on the inadequacy of government action, and also required lawyers to think about how they can use the law to push for change. So among all these cases that are considered to have flooded the courts, this was Jeffrey Sachs that we're using this expression, especially, and that's why generally I work more on comparative law cases, comparative law perspective than on international one, especially before domestic courts. We have several types of climate change litigation that have been distinguished. So here you see quite easily what we call the strategic cases. So these are maybe the most famous one, the more sexy. There are those cases with a visionary approach, those cases on climate change that aims to influence public and private climate accountability. And then there are also, of course, very, very important, the routine cases that are less visible, less sexy, let's say, and in a way they deal, for example, something that is fundamental, but maybe a little bit more technical. That's why the newspaper, they like less to pick on this, like, I don't know, litigation about planning application or allocation emission allowances under, for example, the EU ETS, the emission trading scheme. So these are less sexy, I would say, more routine cases, but they are very important. And then we have another distinction, which is always made by the literature between proactive litigation that are initiated in order to engender policy change, for example, by requesting the adoption or reform of legislation. And on the other side, we have what we call the reactive litigation. And in this case, as you can imagine, the idea is to initiate this kind of litigation to resist such change. For example, by challenging the adoption of a new and reformed, better climate change law or legislation policy. So interestingly, the scholarly and the media attention, as you can imagine, on climate litigation tend to focus on cases that seeks to advance climate action, what we call the pro-active or pro-regulatory cases. However, not all the climate litigation is filed with that aim in mind. We have to make to be sure that this is something known. I mean, there are many recorded cases in which the litigants challenge the introduction of a regulation or policies that would lead to greenhouse gas emission reduction or even other positive climate outcomes. So there are cases against this kind of, let's say, environmental evolution. And we call them this kind of litigation, also anti-regulatory litigation, defensive, or even just anti-litigation. For the most part, they are filed by litigants who have a financial or ideological interest in delaying or obstructing climate action. You can imagine who. And however, not all cases challenging the design or application of climate policies and measures fit in this description. Increasingly, we have cases that have been filed that might not have opposition to climate action as their main objective, and yet may delay the finalization or implementation of climate policy responses. For example, individuals bringing rights-based climate cases might not object to climate action, because of course, but rather to the way in which such action is carried out or its impact on the enjoyment of human rights. These cases are also a new kind of trend of cases that we are studying. For example, this is part of my work in Glasgow. They are called just transition cases. So in a way, we know that it's right to do climate laws, but on the other side, we have also to consider other aspects that maybe are not just, the interest of some lobbies that are going against this innovation, but there are other elements like human rights or labor rights, or maybe some interest on some indigenous community. That's why a part of the scholarships use the terms climate aligned or non-climate aligned cases. Climate aligned is used to describe cases seeking to advance climate measures. Non-climate aligned is used to describe both anti-regulatory cases aimed at delaying climate action, and also these new, as I said, just transition cases. While we can say that this latter group of cases may not advance the short-term climate outcomes intended by the defendants, such case may in fact result in better outcomes for the climate in long term. For example, ensuring that the transition to low carbon economies is done in a way that is fair and equitable, not only as a moral imperative, but also as an instrumental necessity for ensuring the long-term success of climate action. So we have to consider the complexity of climate action, of climate change fight, and also climate litigation, and considering that sometimes there are cases that goes against new policy or legislation, but they are not completely against the progress of climate action. So after this, I just want to give a few elements on climate change litigation. Just as I said, this is a sort of short overview because the time is limited, but the idea is to give some pointers on the most interesting aspect that we should find this kind of litigation. So of course there are several dimensions relating to climate change, adjudication, litigation, and we can see this through the function of litigation, the sources of law involved, and of course also the different fora where the climate related cases are brought. So we are going to see a little bit a lot of this with some cases, so we have maybe also a more interesting idea. So talking about the function of litigation, as you can see here, this slide is quite confusing, it could be, but also can show us that climate change litigation can serve potentially overlapping functions. So some cases, of course, they are maybe the most famous, they are just seeking to limit greenhouse gas emissions, for example, by compelling legislative or regulatory actions, as we said before, could be really like a sort of problem then with the separation of powers, but then I think we will discuss about that later. For example, there was a case, there was the World Heritage Committee petitions, so we are going into the international law there, that sought an opinion that the World Heritage Convention obligates states, the states parties, to reduce their emission in order to protect World Heritage sites that were and they are threatened by climate change. And one of these examples is the Great Barrier Reef. Now, I don't want to open another brackets, but as you remember, in 2018, we have this great work of the scientists, which was the special report on 1.5 degrees. And there we realize how much different could make even just 0.5 from 1.5 to 2 degrees in our medium long-term objectives in terms of reduction emission. So, for example, according to this report, according to the Barrier Reef, I remember they said if we stick to the 2 degrees, which, as you know, for the moment is already a good objective, a good goal. If we stick to keeping the emission below 2 degrees, we know that we will have 70 to 90% of the coral reef that is going to be destroyed. While if we go to 1.5 degrees, maybe, sorry, it was 99%, so almost all of them. While if we go to 1.5, 70 to 90, I mean, 70 to 90% of the coral reef destroyed is already impossible to consider something not catastrophic. But if you think that with 0.5 more, we arrive to practically the extinction of the coral reef around the world, that is even more worrisome. So this was the case, as I said, the World Heritage Committee petition was quite important. Until recently, both international and domestic tribunals were reluctant to find that international law requires government to reduce national emission, given the far-reaching implication such this kind of rule would have. And this is also the problem that I already mentioned, of the separation of powers. It's difficult to consider in a legal system that the judges are going to contradict the executive or the legislative power. But, you know, this is really something on which we studied, we organized several research and events, so we can discuss about this. In the case, as I was saying, involving the Great Barrier Reef, the World Heritage Committee found that the issue of emission mitigation was being addressed in the UN climate regime, which is a sort of, let's say, our executive or maybe legislative kind of international level, and instead decide to focus on the problem of adapting World Heritage sites to the impacts of climate change. And similarly, there was another case, there was a Canadian case that was brought by Friends of the Earth, in which the court found that the issue of whether Canada had violated the Kyoto Protocol was a political question, and concluded that Canada had no role to play reviewing the reasonableness of the government's response to Canada's Kyoto commitments. So in a way, the judges, they didn't have a say into this kind of matters, because these were something that was a government, it was the government arena, let's say. However, there are also, as I said, a number of national cases that have held that the government can or must take into account climate change in its regulatory and administrative decision making. And so, for example, we will see that in a while, the plaintiffs were successful in the US in a very famous case that you should note down because it's one of the leading cases in the US, Massachusetts versus EPA. I'm sure that you already know about this. Is the American leading case in the field, and in a way, the plaintiffs were successful in arguing that US federal law allows the Environmental Protection Agency, the EPA, to regulate greenhouse gas emission, since this outcome left decision about emission mitigation in the hand of EPA rather than the courts. So cases involving permitting decision by the government have also had some success, since they concern a little bit the legality of particular project, as I said before, under existing national law, rather than requiring the courts to make broad political charge rulings. So these are the cases that I was saying before, the routine cases. So in a way, they are less charged with this politically kind of debate, But on the other side, they could be also more effective because, we can talk also about international duties to reduce emissions. This is the case that was decided, for example, a few months ago in the UK, in many other parts of the world. New Zealand courts, for example, have held that the government must consider in deciding whether to permit the construction of wind farms and coal-fired plants, the effect of a proposed project on greenhouse gas emissions. This is huge. Australian courts, Australia is, as I said, a very interesting country from this point of view. They also have held that permitting decisions regarding power plants must take into account the effect on greenhouse gas emissions. And we just can go back to the Rocky Hill case and the great decision by Justice Preston that was particularly followed in other parts of the world. So more recently, several courts have gone even further, as we will see, and have directly ordered the government to take stronger climate action. And so, as you probably already heard this name, the most famous case probably in the world is the Uganda case that we'll see in a while, where a Dutch court ordered the government to adopt a stronger emission reduction target. And even another one on the other part of the world, because it's not just from Europe that we have this kind of interesting cases. Another very interesting case is the Laboratuvarı case. Also, we are going to see in a while, where the Pakistani Lahori High Court ordered the establishment of a commission to oversee the implementation of the government's adaptation plan. So another category of cases involves, as you can see, tort claims for climate change damages. This is something that will be even more important when we're talking about corporate climate litigation. Although such claims can have a deterrent effect on future emission, their immediate goal is to provide compensation to the victims. So also very important from the point of view of the remedies. One of the main barriers to such cases is the problem of defining climate change damages and also of attributing them to particular actors. We are arriving there, but the science for many years was trying to find a way. So at present, let's say that most that science can say is that climate change increases the likelihood of intensity of a particular kind of event, like a heat wave or a storm. This is something that we practically all of us already lived in these years, but not, unfortunately, that climate change is the but-for cause, which is important for this kind of litigation, for the causal link. And this is something that really is part of many interesting work by scientists, also by scientists and lawyers in this moment. I'm thinking about our colleagues from Oxford that are working on in the last year on the attribution science. And so they put together great scientists and scholars from a legal perspective to see a little bit how this could work. Finally, even if unsuccessful, climate change litigation, as you can imagine, can also just help raising public awareness. So it's also important when the case has been lost in a way. So by focusing on particular victims, on particular impacts, litigation, in a way, it's important because helps give climate change damages a human face. Some of climate litigation, for example, as we will see, the famous Inuit petition, these tell a story about the impact of climate change in human terms, far removed from the antiseptic discussion of greenhouse gas concentration or global mean temperatures that have traditionally predominated international climate negotiation, as we know. And so, for example, even some petition to the World Bank inspection panel cannot compel a project to be stopped, of course, but by focusing the attention on the harms caused by the project, a petition before the World Bank inspection panel can help mobilize public opposition and thereby also influence decision about whether to allow or to modify the project. So as you see, the function of litigation already shows us a very heterogeneous kind of overview. Let's go now to the sources of law. So, as I've said, climate change litigation also varies depending on the source of law involved, of course. A few cases have alleged violation of international law, that's already said. For example, that case that I mentioned, the Friends of the Earth case in Canada, they alleged violation of the UNFCCC, of the Framework Convention on Climate Change, and the Kyoto Protocol. The proposal by Palau to request an advisory opinion from the ICJ and now from Vanuatu have explicitly focused on the responsibility of state under international. This is something also to be monitored, because in these days it's happening again after something that was in the 2005, now again 2011, then now again brought by Vanuatu, this idea. And I mean, we are quite positive about this. We will see. And as I was saying before, the Inuit petition also, in a way, alleged violation of international human rights law. The World Heritage petitions, as I said before, concern putative duties to mitigate emission under the World Heritage Convention, so another international law source. And we had also decision in Africa. There is, as you can see, this Nigerian decision of natural gas flaring by oil companies that found that flaring violated human rights of the local population, because of course, and now we understand even better, thanks also to this last summer new resolution by the UN General Assembly. So this is quite interesting field, and also the Nigerian one, they were not only based on the Nigerian constitution, but also under the African Charter on Human and People's Rights, which is one of the first, if not, I think the first text in the world talking about this right to a healthy environment. In some cases, the international one. In some cases, national courts have employed international norms for interpretative purpose. In Legari case that we are seeing a little bit better in a while, the Lahore High Court looked to the principle of sustainable development, precaution, intergenerational equity, in finding that Pakistani government was violating the fundamental rights of its citizens by failing to implement its climate change adaptation policy. And at the same time, and almost at the same moment, because it was a few months later, in Urgenda, the Dutch court looked to international norms such as the 2 degrees temperature limit, in finding that the government had breached its duty of care by failing to take stronger mitigation measures. As you remember, the 2-degree temperature was reached in 2007 with the 4th assessment report by IPCC, the year when they won also the Nobel Prize. So all of these, as you can understand, show us also a very interesting perspective from the point of view of different kind of sources that can be mobilized. Many of the cases to date, as I already said, however, have involved more national rather than international law. That's why generally we work from a comparative perspective, as I say. The cases that already mentioned brought by US court, they have concerned the Cleaner Act, the one from Massachusetts versus EPA, but many other legislation too, the National Environmental Policy Act, the Public Nuisance Law, the Endangered Species Act. Also cases like in Germany, a German case requiring disclosure of the climate change impact of project, supported by the German Export Credit Agency, was decided on the basis of the German Access to Environmental Information Act, so also very precise kind of legislation. And as I said, also from the point of view of Oceania, New Zealand and Australia cases concerning power plants, permits, involved the Resource Permit Management Act of 1991 in New Zealand cases, and the Victorian Planning and Environmental Act in the Australian cases. So very specific legislation in each legal system that could be used as sources of law. That's normal. In most instances, national laws such as these establish more precise obligation that international agreement, as we all know. The UNFCCC it's a great convention and is the basis of an international regime. But of course, even how it was built since 1992 and even before, was built with the mechanism knowing that we need them to have a protocol, and even the obligation weren't that strict, or maybe too strict when we were talking about the Kyoto Protocol. We can talk about also World Heritage Convention. In a way, these are less precise than the sources that can come from domestic legislation. And so, in a way, domestic litigation can provide, domestic legislation can provide a stronger basis for judicial governance. That's why it's quite important. And so let's finish this, this part of the introduction with a third variable in climate change litigation, which is the forum where a case is brought. In addition to national courts, possibilities at the international level, because of course we said national law, national courts may be the best place, but international law is still very important. And so we have, I just put several of that. If you have the possibility of consulting our book that we prepared last year on global perspective, on climate change litigation, global perspective, you will see that we studied also some interesting prospects. Some of these prospects that we studied last year, in this moment, are already in the process of realizing themselves. So quite interesting. The International Court of Justice, for example, there was an interesting chapter wrote by Margareta Beverinck and other colleagues, and they were talking about what's happening in this moment. So, of course, as you know, few states currently accept the compulsory jurisdiction of the ICJ, but anyway, an ICJ ruling would most likely take the form of an advisory opinion, and would clarify also the framework, what we are working with in this kind of cases. So this is what I say Vanuatu and the coalition of states, not only state island states, are working on in just this moment. The International Tribunal for the Law of the Sea, LOS, of course, which has jurisdiction over cases involving the UN Convention on the Law of the Sea, but also other conventions like the 1995 Fish Stocks Agreement, and many other related agreements to this kind of milieu, this kind of field. And these also could consider claims concerning the damage to the marine environment, which, as you know, is always related to climate change. The dispute settlement panels and the appellate bodies under the WTO's dispute settlement understanding also are quite interesting, because they provide a forum for disputes involving national climate policies that implicate trade law. As you know, some cases involving feed-in tariff for renewable energy, they've already wound their way through this system. And we have many other, the International Center for Settlement of Investment Dispute, and this is ICSID. And these are also quite interesting cases have arisen that tangentially related to climate change, involving also the issuance of permit for coal, fire plants. This is always one of the big topic, of course, because we try to shift from these kind of energies. But it could be also claims that challenge subsidies for renewable energies. It's not just in one sense. So the Permanent Court of Arbitration also consider, for example, cases brought by investor in joint implementation projects concerning the transfer of emission reduction units. So, you know, this is a kind of international flexible mechanism. And then we have really a lot of interesting ideas, and also in this moment perspective from prospects from the point of view of the regional human rights tribunals, like the Inter-American Commission or Court of Human Rights, European Court of Human Rights. And this is, for example, the case of the unit petition. Let's say that, however, although cases like the unit petition have attracted a great deal of attention, they have not been successful thus far, except as a mean, as I said before, of raising public awareness on this kind of topic, on the need to fight climate change. And so in particular, the lack in most cases of compulsory jurisdiction or enforcement authority is one of the reasons why we need to continue to experiment. So even if small island states succeeded, for example, as I was saying, they're seeking this advisory opinion from the ACJ, the state will have always the responsibility to reduce emission. So what means that this kind of advisory opinion would at best put pressure on the states in the UNFCCC to reach a stronger agreement rather than directly cause them to reduce their emission, because as we know, international, unfortunately, is not that, let's say, is not that powerful from this point of view. In contrast, as I said, litigation in national courts has somehow a greater success, particularly challenging government decision or net zero strategies, for example, approving permits to construct power plants, or providing export credits for energy project in other countries. And so, as I said, this is quite interesting. So yeah, if you want to have a more precise idea on this, this is the book, the first one on the top left part of the slide, which is divided in two parts. This is the book that we published last year. One, the first part is the analyzing the 10 legal system, the most interesting one, at least from the point of view of the climate litigation, UK, US, Australia, France, Netherlands, China, Russia, in which there are just prospects. There were, now there are South Africa. And on the second part, there were international perspective and a very interesting prospect on this kind of, for example, fora that we see. And why we talk about global perspectives, of course, it's quite obvious the diversity within the climate change litigation literature about the definition, as I say, of the phenomenon and the studies is in a way also a reflection of the breadth of climate change itself, of its complexity, of its multidimensional kind of aspect. And for example, the global nature of the problem of excessive greenhouse gas emission is coupled with the many localized decisions by multiple actors that go toward addressing the issue as part of, as I said before, this global governance of climate change. And this global governance, that's why I put some other interesting books that could be of use. This global climate governance, beside the action taken by international organizations, by the states at the international executive level, is also to be considered as encompassing the role of domestic, international court, and human rights bodies, as I was saying. That's why this kind of perspective appears to be necessary for what could be an analysis that is more comprehensive, that is more inclusive also of the different problems related to climate litigation. And so, in a way, we have both dimensions, the comparative one and the international one, when we talk about global perspectives. I'm going to go quite fast through the different kind of cases that we are going to see. I don't know how much time do we have left, because we started a little bit later. So I just try to finish at least a short overview on those. So quick overview over a few climate litigation cases. As I told you, litigation cases around the world, now there are more than 2,000. So really, these are some of the most interesting, I don't want to say important, but some of the more interesting and more mediatic cases that we had. We start with the successful one, the one that already mentioned, the landmark Pakistani case of Asghar Leghari. Here, the government of Pakistan was sued by a farmer, Asghar Leghari is a farmer, for failure to implement its 2012 national climate policy and framework. The judge, which is also one of the interesting things about judges in the Global South, found against the government, that was 2015, and established a climate change commission to oversee the proper implementation of this kind of policy. And you know, an interesting fact about this is that even before the case has been decided, climate change legislation was enacted in Pakistan. So in a way, this is really showing the influence of the litigation on the legislators, as we were saying, raising awareness, but also the nudge function, trying to push a little bit a legislator to do something that, if not, would be considered illegal or illegitimate. So along with this long history, of course, of public interest litigation, Pakistan also has more relaxed standing rules, which is quite important, especially when we compare to some jurisdiction in the global north, and without saying the US, but yes, and the judiciary demonstrate to be a dynamic and interventionist actor. Another, maybe the most famous example of domestic crime litigation is the Uganda case, as I said before. That was another landmark decision. The Dutch Supreme Court decided this case after the first and the second instance, and the Dutch Supreme Court ordered that the national government has to reduce its greenhouse gas emission by a set amount. And that was the first time that something like this had happened anywhere in any jurisdiction. So that was 20 December 2019. The Supreme Court agreed that the Dutch government had violated Article 2 and 8 of the European Convention on Human Rights, and upheld the said reduction in greenhouse gas emission by the end of 2020. And recently, the Dutch government announced its plan to comply with the ruling, including the idea of a capacity of its remaining, reducing a capacity of its remaining coal-fired plants in all the station by 75%, and implementing a 3 billion euros package of measures to reduce greenhouse gas emission in the Netherlands. So the reasoning of the Supreme Court focused on the violation, as I said, of the two articles that we cite the most, that you already know very well, of the European Convention on Human Rights, characterizing climate change as posing an immediate real risk to the right to life, Article 2, and the right to family and private life, Article 8. So this was quite interesting. An interesting argument that was used in this case, then we found everywhere, because this case, in a way, was really a case that spread and created a diffusion of reasoning and ideas around the world, also thanks to the climate network that work behind this. So one of the interesting arguments that the government defendant in climate litigation also more often invoke is what we call the drop in the ocean argument. I don't know if you heard about this, but basically, according to this line of defense, greenhouse gas emission coming from any individual country or from a particular activity are negligible as a contributor to global climate change, and therefore cannot be said to cause climate change harm or have a significant environmental impact in global terms, because, as we said, it's like a drop in the ocean. However, until so far, let's say, no national court has accepted this line of argument during merits proceeding. And in the Uganda case, the state argued that the Dutch emissions are small. Yeah, they said it's just 0.4 of the global emission. So why do we have to be punished for this? Do we have to receive a decision on this? And also they say that the Dutch government, they said that tightening its emission reduction policy would be just a drop in the ocean in the global fight against climate change. And already the Court of Appeal relied on the per capita emission data to stipulate that the Netherlands is the biggest per capita emitter in the EU. So if you see, we change perspective. We don't think just as a whole world 0.4, what is 0.4? No, let's see from the point of view of the per capita emission, what we do as individuals. And then we realize that the Netherlands, the Dutch people, they are the biggest per capita emitter in the EU. So that's why it was so important. And also, the Dutch government had indicated that avoiding climate change impacts requires strict policies to be adopted across the world. And since it cannot influence this domestic policy abroad, Netherlands cannot be required to reduce emissions in its own accord. And of course, even there, the Court of Appeal rejected the argument, pointing to the special position of the Netherlands. And it is also what we find in the Paris Agreement, because, you know, according to the Paris Agreement, as developed countries, we have to be the pioneers. As a rich developed state, the Netherlands, that has gained also much of its wealth through extensive use of fossil fuels, so the historic responsibility, they have to do something more. And this is something that then we see in many other cases. This is the main reasoning that was used on the German Constitutional Court case and the Neubauer case, the Belgian court, or for instance, in the climate sack, and also Notre Affaire à tous in France in the first court of first instance. So this was really the leading case because it spread a little bit everywhere, this kind of interesting and important reasoning. The US, the Juliana case, maybe it's something that also you heard about. This is more an intergenerational case, even though the people that are there, they are all living and well-born. They were 21 young people seeking declaration by the federal court that the government had the legal obligation to fight climate change under what we call in the US, the public trust doctrine, and of course, the US Constitution. And this is something that has been attempted a little bit in different cases in the US on the basis of this doctrine. But generally, this is also the kind of argument that is being dismissed on the ground that the doctrine doesn't apply, or that the petitioner, the plaintiff, lacks standings to sue, or the judicial action would interfere with legislative and executive powers. Again, separation of power at the highest kind of level. And yeah, this was a case that unfortunately it was quite interesting at the beginning because was allowed its application, the public trust doctrine in the first instance. And then there were several appeals by the Trump administration. This was before the new government. And in a way, the case had been dismissed on 17 January 2020 and by the Court of Appeal for the Ninth Circuit. And in a way, this is quite important because it shows something that the government not just allowed, but actively contributed to the climate-related harm suffered by the 21st young people who brought the claim. That was in a way recognized by the judges, but they say, but we don't have to say anything about this because this is something that has to be discussed with the parliament, with the government. It's not us to decide. So always the same kind of argument by the American judges. I just finished maybe with the milieu defenses versus Shell. And just because it's a very critical case, and also because, as I said before, we are working at DICOL a lot on the corporate climate litigation in this moment, and is also another case coming from the Netherlands, the milieu defensive versus Shell case, is an example of litigation that integrates the interpretation of corporate due diligence based both on human rights law and climate law standards. And this is quite interesting because Royal Dutch Shell for France is Europe's largest oil and gas business by revenue. And as you know, this has operation practically everywhere, more than 70 countries. And in this decision, in a way, this is a decision that was stimulated by, again, environmental groups, Friends of the Earth, Milieu Defensie in the Netherlands, together with 6 other NGOs, and they brought more than 70,000 Dutch citizens. They want to sue this oil giant, alleging the Shell contribution to climate change violated its duty of care under Dutch law and its human rights obligation of business enterprises. So, you know, the case was decided last year in May 2021, was a groundbreaking decision. The Hague District Court ordered Shell to slash the emission by 45% by 2030 relative to 2019 levels across both emissions from its operation and emission from the use of the oil it produces. So it includes, incredibly, scope 1, 2, and 3 emissions. So across its entire energy portfolio. And in March, of course, 2022, not surprising, Shell appealed the decision. And so the case in this moment, as you know, is pending. And this is quite interesting because this landmark ruling sets a precedent that corporations can be held liable for inadequate action to curb climate change, and also must cut their emission in line with global climate goals. In a way, this is quite interesting because it was the first successful case of this kind. That's why we are working on this field, and we want to have more effective, at least, kind of cases. And it's quite interesting because the court interpreted the unwritten standard of care as an obligation of Shell from something that is in the Dutch Civil Code, the section 162 of the Dutch Civil Code, which means that acting in conflict with what is generally accepting according to unwritten law is unlawful. And of course, its content is also informed by the Article 2 and 8 of the European Convention of Human Rights that you already mentioned. The court, just to finish about that, gave Shell flexibility in allocating their emission cuts between scope 1, 2, and 3 emission, so long as in aggregate, the total emission has to be reduced by 45%. Okay, this is just the last slide, so we can finish with that. This is the international perspectives. These are, in a way, three kind of cases that are representing the past, the near past or the present, and the present future. So it's important, as I said before, even though domestic, probably also because we have almost 200 countries where we can bring this kind of cases, but also international litigation is quite important. And is necessary in a way to complement the international climate change regime, which is limited, as you can imagine, by political compromise, and we know what's happening every year at COP. So we don't have to hide behind a finger. So some weaknesses of the mechanism to review the adequacy of state compliance and other. There are different opportunities coming from this. Of course, let's start just giving a real fast overview of this. This of 2005, Sheila Watt-Cloutier and other versus the United States is one of the first international climate change ever, climate cases ever. So it's a petition before the Inter-American Commission on Human Rights. It provided a full analysis of the possible violation of the Inuit people's human rights. That's why we call the Inuit petition. If the US, the United States, failed to adapt their policy to mitigating climate change. The case, unfortunately, it was 2005, was dismissed even before consideration of its admissibility on the ground that claimants had failed to identify concrete acts of omission that US government that constitute a violation of rights. That was 2005, by the way. This was, of course, a missed opportunity for the inter-American system to consider the link between climate change and human rights. But then we know that this is something that has been, in a way, fulfilled. And but before, also because it was before climate litigation became a trend, a global trend. The second one, the very famous case in this moment, was filed in 2019 before the UN Committee on the Rights of the Child. It was the first petition on children and climate change. I don't know if you remember, it was the case in which was involved Greta Thunberg and 15 other young people from across the world against Argentina, Brazil, France, Germany, and, as you know, Turkey. That's why it was quite important to remember. The relief sought are findings that climate change is a children's rights crisis. The respondent states are recklessly perpetuating this crisis, and in doing so are violating children's rights to life, health, and the prioritization of the child's best interest, as well also the rights of indigenous children to their culture. This is something that we will find always more, especially considering the adaptation side of climate change. And also, additionally, the petition asks to review and amend the national laws to accelerate mitigation adaptation to climate change. So this was something quite interesting. I was working, we were working in organizing some research with one of the plaintiffs in this kind of case, the Hausfeld Global. And on October 12, 2021, last year, the Committee on the Rights of the Child unfortunately rejected the claims as inadmissible. However, the judgment was really interesting because the committee again accepted the claimant's argument that the states are legally responsible for the harmful effect of emission originating in their territory on children outside their borders. So the transnational side is really interesting. And also the fact that all states are causing climate change does not absolve each individual state of individual responsibility to reduce their own share of emission. This is quite interesting, but as you know, the reason why the court decided to reject this kind of case was that the complaint was inadmissible for a failure to exhaust local remedies. As you know, this is something that we need to do. We don't have the time to finish with the litigation cases before the European Court of Human Rights, but they are very important. There are several cases that in this moment are pending before the courts. These three are some of the most important. So, as you see, the Duarte Agostini and others versus Portugal and 32 other states, the Union of Swiss Senior Women for Climate Protection, and the Greenpeace Norway versus the government of Norway. Just say that where the two first cases take a government framework approach, the Norwegian case is more narrowly targeted at oil and gas exploration. And it's quite interesting because now we know that the Swiss case will be dealt by the Grand Chamber of the European Court of Human Rights. And so it will be probably the first one to be decided. And in a way, this is really a sort of very high profile for this kind of cases to be brought before this important part of the European Court of Human Rights. Let's say that this is just where my overview will finish. I had also some conclusion, but it's just by saying that this is climate change litigation is being used always more as a tool to pressure governments to adopt more ambitious climate policies. There always been an increase in complaints launched before international and human rights treaty bodies and regional courts, and also that the consciousness of this ecological interdependence among states is triggering the need of this dialogue that I was saying in the beginning, the dialogue between the judiciary, the dialogue between different legal systems, cooperation, and legal collective response if we want to tackle climate change in an always more effective manner. So I finish here for the moment, and I think that I exhausted a little bit my time, but I remain at your disposal if you have any question about this.
Dr. Alogna, thank you very much for this absolutely fascinating lecture. Thank you very much for introducing us the general framework of climate litigation and then highlighting very interesting and important cases. It is very interesting to see how litigation, even before giving a decision, can affect the policy decision. We have really learned a lot from your lecture. Thank you very much. And,
thank you for listening.
And now we can start questions and discussion session and take the questions and any comments of our audience.
Actually, I have received a question from Mr. Fayaz from the chat box, and maybe I can read it for him. And the question follows as, has the international environmental diplomacy played a role in mitigating transboundary environmental harms?
I am. This is something that has to be seen, and in a way, diplomacy is quite important. As I was saying before, climate litigation is not something that happens in the emptiness of the global norms. We have an international regime, and we have states that meet every year to try and find a way of dealing with this. From a transboundary kind of harms, let's say that diplomacy has played more a role in trying until so far, let's say, to protect their states, their companies more than, you know, in trying to find some solution. And that's why then we find ourselves asking for advisory opinion or going before international courts, because in a way we see that the political aspect of dealing with climate change, as we can see at COP, as we can see in other menus, is really exceeding, unfortunately, the effectivity of the instrument that we are trying to create for fighting climate change. So, yeah, not much. In this moment, there are some interesting cases that are going in that direction. You may heard about Luya versus RWE or the Olsin case in Switzerland. So we are talking about a case brought before German courts by a Peruvian farmer, or another case brought by Highlanders from the Pacific to Swiss courts. This is something that is going into the direction. States, according, you know, in my opinion, not that much.
Thank you for your answer, Dr. Alona. And do we have any other questions via chat, or maybe you can raise your hands? While waiting for a question, maybe I can use this opportunity to ask you a question.
Yeah,
I'm currently working on my PhD thesis, which a part of it covers climate litigation. And sorry if my perspective is too narrow on private climate litigation, but I wanted to ask, do you think national courts has to be welcoming for victims of climate change, or do you think is it utopic to think about an international agreement, or maybe a supranational system for future mitigation in general? Thank you.
Yeah, I think that it's not utopic to think something like this. If you've seen, there has been also this interesting decision by in the Billy versus Australia case in September, in which we have also finally a decision that goes in the sense of protecting people that are endangered by the rise of sea level. And this is something that we will see always more. And I think that, no, absolutely. I think that your thesis and what you are going to work about is really fundamental. And if I can suggest, just try to keep your perspective as much open as possible, because sometimes we will find some interesting solution in other legal systems, sometimes even far away from ourselves. That's why I try to pick some cases from very different part of the world. And even the international level, we have very different kind of, as I explained when I was talking about the fora, very different kind of perspectives, because fortunately, we can bring cases that could be really, really different one from each other. So yeah, my response is absolutely yes. And I would look forward to reading something about this from you. Any other question?
Hello, Dr. Alona. This is Tariq Faiz. Am I allowed to ask a question here on this forum? I may take a liberty.
Please.
Thank you.
Yes,
Thank you so much. Thank you so much. So my question again relates to the coming of the fifth pillar in as an ecocide. How far this tortious liability for the transboundary national environmental or international environmental harm is going to be affected when this ecocide law comes into picture? I mean, this is a far-fetched idea, but when, how do you think from the tortious liability to the corporate criminal liability? So you have spoken about the transboundary international harm. How do we see that realizing in the near future? Thank you so much.
Thank you very much. Your question is quite complex to be replied, because yeah, there are let's say that there are two kind of very interesting laboratories in this moment that are at stake. On one part, there is the ecocide that, as you know, have been defined last year by this group led by Philippe Sanz, and it's quite interesting because in a way, the idea is to work at the international level to modify the Rome Statute. So, I mean, I don't want to be pessimistic, but for what I can understand of this and for what I've studied, this is something that has to be done, certainly, but it will be really difficult. I'm working myself in a group on the eco side at the European Law Institute, with the European Law Institute, and we are proposing something at the European Union level. So this also will be quite difficult, but you never know. Maybe we can propose something that will go in the future amendments of the 2008-99 directive. I don't know. This is something that will be discussed in the next months, in the next years. I think that opening to any kind of instrument and ideas, even though until now they have been ridiculized or they were considered too extreme, I think is never a bad thing. Then, if you ask me, is going to work like tomorrow? No, maybe in a few years, maybe even in 2-3 years. I don't know, because now the rapidity of the evolution in our field is really incredible. That's why it's important also to do this kind of scholar work as the one that we are trying to do at BICOL and many other parts at Sabin Center. All these network, all these different kind of groups, they are working in different areas and they are pushing the boundaries of our of law, of climate change law. So yeah, ecocide is one thing. I would separate it from the other aspect that you were saying, which is more related to different kind of causes of action. I mean, could be tort law, could be any kind of, could be human rights. I mean, it depends what we use to have the same kind of let's say remedies, the same kind of outputs. So yeah, I think that I think that both kind of avenues are really worthwhile to be explored. I'm not sure that they are compatible. I'm not sure they will influence one each other, in the sense that, yeah, when we have a breakthrough in one sense, we have the impression that we are going to open the gate for any other. But it's not exactly like this, because it depends where you want to bring the novelty, what kind of institution, what kind of causes of action, for example. So yeah, it depends. It depends. Anyway, thank you very much for your question. It was very interesting.
Thank you so much, Doctor.
Any other question? I know that is really late for you. For me, it's 7:30. For you, probably even later. So I can imagine that the people start to be a little bit.
Yes, exactly. It is a bit late, not very late, but it's evening hour. So
Yeah.
maybe for this, I think there is no question or comment. And now, unfortunately, we have come to the end of time allocated to us for the seminar. And I would like to thank everyone in the audience for their questions, and of course to Dr. Alogna'yı for his contributions and presentation and insightful answers. And I hope everyone enjoyed today's lecture. And I wish everyone a wonderful new year. It is end of the year almost. And yes, before we finish, I would like to take your closing words, Dr. Alogna'yı, before we finish.
Yeah, I mean, when I'm talking about climate change litigation, since this is was the topic of the lecture, as I said, as I said also at the beginning, we are talking about something that is complementary of what is already done by the international community in the last 40 years. But on the other side, we don't have to forget that this should be considered the second best option. The first best option should be some good legislation in this. That's why I'm working a lot on climate litigation, because I believe in this, but I believe also that we should continue to push for better climate change laws and policies. So in a way, yeah, let's consider that. And let's try also to keep an eye to the work of our judges and to help them to establish some more interesting kind of rules with us. So thank you very much for your invitation. It was a pleasure to discuss with you. And I wish you also a pleasant winter break and a happy New Year. So I look forward to meeting you again, or in Paris or in London, and to exchange again with all of you. Thanks again.
Yes, or in Istanbul. Thank
Or in
you.
Istanbul. Yeah, with pleasure. With pleasure.
Thank you.
Love
Thank
Istanbul.
you very much. Thank you. And goodbye, everyone.
Thank you. Thank you so